Good afternoon, and thank you for joining us for today's webinar, Protecting Yourself and Your Team, Coverage Essentials for Businesses. I'm Sarah McDonald from the Branding and Stakeholder Engagement Unit at the Workers' Compensation Board, and joining me today from our Advocate for Business office is Walt Peretti. Today we will discuss the basics of workers' compensation system, including insurance types, coverage requirements, and employers' obligations under the law. We will also cover who needs coverage and who does not need coverage, how and when to report an illness or injury, considerations when hiring independent contractors, laborers, and domestic workers, lowering premiums and penalties, and where to go to get assistance with them. We will be using the chat feature to receive your questions today. Please enter your questions throughout the presentation in the chat box located on the right side of your screen. Walt will answer as many of your questions as he can, but if there's any he doesn't get to, or if you think of something after the session ends, we'll be providing you with additional resources at the end of the presentation. Also, your name and email were given to us when you registered. However, if you have a specific topic you'd like to discuss more deeply with the board, please share that topic along with contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are set so that only panelists can see any questions that come in, so you don't have to worry about others seeing your personal information. And with that, I will hand it over to Walt.
Good afternoon. Thank you for joining us today. My name is Walt Peretti from the Advocate for Business office. Usually our Advocate for Business, Anthony Tomaselli, does this, but he's away at a separate speaking engagement, so I'm your host for this afternoon. So just, we're going to go over the coverage basics, who needs coverage, who doesn't need coverage, the costs, how to control those costs, through some safety issues, what to do in case there is an injury, and then, as Sarah stated, we'll have time at the end for any type of questions that you may have. So what is the Workers' Compensation Board? We were created about a century ago, in 1914, after the Triangle Shirtwaist Factory. We oversee the workers' compensation, disability benefits, and paid family leave law. The board receives reports of injuries, payments, and authorizes medical providers to treat injured workers. Currently, we have approximately 1,050 employees with offices and hearing sites across New York State. And in the event that there's any type of controversy as to whether the injury is compensable or happened on the job or not, we would hold hearings to adjudicate those types of disputes. Our office, we're here to assist individual businesses with coverage and compliance issues. Like we're doing today, we educate business owners and government personnel regarding the workers' compensation systems. We go out in person and meet with business associations, employer groups, et cetera, chambers of commerce, listen to their concerns regarding the workers' compensation system. And our unit reports directly to our chairperson, Clarissa Rodriguez. So we're hearing the same type of theme over and over, certain pain point that might be in the process. We can report back to the board and see what type of legislative fixes they might be able to bring up to the legislature to kind of make it easier for businesses. Okay, so workers' compensation insurance, it covers any on-the-job injury, illness, and accident. Right? So if you're injured on the job, whether you're performing your duties or you're home at work performing those job duties, you'd essentially be covered for the life of that claim, for the life of that injury. You never have to pay any type of co-payment, lab fee, testing fee, et cetera. It's there to provide both medical and wage replacement. So if you're injured on the job, you can collect 2/3 of the average weekly wage in New York State, up to a maximum of about $1,800. And you'd also, again, all your medical would be covered. It's just like your auto insurance. It's there to protect both sides. So it protects both the employee and the employer. Disability benefits covers anything that occurs off the job. So if you went home tonight and you're mowing your lawn and you trip and hurt yourself, there'd be some coverage for that. With the disability benefits, there's no wage replacement, and it's limited in terms of it's only up to 26 weeks. You have to file that claim within 30 days of becoming disabled, and it's at the maximum as far as wage replacement is $170 up to those 26 weeks. Paid family leave came about 7 years ago, provides paid time off for employees to bond with a child, whether that's birth, adoption, or foster care. You can take paid family leave to care for a family member that has a serious health condition, or assist a family member that's deployed abroad on active military duty. Okay. For PFL, the reimbursement rate is the same for workers' comp. You can take up to 12 weeks, and it's capped at 2/3 or 67% of the average weekly wage in New York State. And again, that average weekly wage is calculated based on the individual's, the employee's last 8 weeks of pay prior to taking the PFL. The 2025 New York State average weekly wage is $1,757.19. So if you make over that, you collect 2/3 of the $1,757. If you make less than that, you would collect 2/3 of what your actual wage is. Those 12 weeks are going to be taken all at once. You can take them a week here, a week there, a day here, a day there. But you always have to take them in full day increments. So if you have a sick family member or a child that becomes ill at school, you can't take a half day of paid family leave. You have to take that full day. Okay. That 12 weeks is for both spouses, or for, so both parents with a sick child or something. You're both entitled to up to 12 weeks. You can take them on a full-time employees who work a regular schedule of 20 or more hours per week are eligible after 26 weeks, consecutive weeks with that employer. If you're a part-time employee and you work a schedule of less than 20 hours per week, you're eligible after working for your particular employer for 175 days, which does not have to be consecutive. And again, citizenship and or immigration status is not a factor in terms of your eligibility for benefits. PFL coverage is not optional for most employees. However, some part-time and seasonal employees may qualify to waive it. And you can only waive it if you're regularly work fewer than 20 hours per week and won't work 175 days in a year. Or if you're regular 20 or more hours per week, but won't be with that same employer for 26 consecutive weeks. So in this type of year, you can see like maybe some of the landscaping, yard work, that sort of thing. Those individuals or those employees might be able to waive that coverage if they meet the above criteria. Can you revoke that PFL waiver? If an employee's schedule changes and they're no longer qualified for that waiver, it will automatically be revoked within 8 weeks of that schedule change. PFL is a benefit that is paid for by the employee and not the employer, unless the employer decides to pay for it. So the contributions for that would come out retroactively from that employee's paycheck. PFL and FMLA, which is commonly known as FEMLA, some of the same benefits they have. It's leave for bonding with a child, caring for a family member that has a serious health condition, assisting when a family member is called to active military duty service abroad. It provides job protection and your continued health insurance during the leave on the same terms as if you had continued to work. So you are protected while you are out of PFL and FMLA. Here's a little side-by-side chart in terms of who's covered, who's not covered. And you can just kind of see with the paid time off. The FMLA is a little more lenient where you can take it on an hourly basis, and you can also use it if you yourself are sick. Whereas on PFL, you can only take it, to care for a sick family member, not your own illness. You can just kind of take a look at that side-by-side comparison. The maximum benefits and contributions, again, it's at 2/3 of that average weekly wage. And then the employee contribution rate is for 2025 is 0.388% of their gross weekly wage. The maximum is $354 per year, which went up about $21 above 2024 level. So again, it's an employee paid benefit unless the employer themselves chooses to cover that. If you want to go to the PFL website, you can go on paidfamilyleave.ny.gov/2025. They have some of that frequently asked questions, some of the model language you might want to use for your employee materials regarding the paid family leave program, as well as the template to calculate the payroll deduction. Okay. And again, if you need more information, that paid family leave website is an excellent resource. There's also a helpline where you talk to a live person from the hours of 8:30 to 4:30, Monday through Friday, with the exception of state holidays. But if you had additional questions on that, you can either visit that website or give them a call. Okay. So who needs coverage and who doesn't need coverage? Okay. So from workers' comp, businesses with employees need coverage, right? We define an employee as anybody that's performing services to a for-profit business. Okay, so whether that's, you know, a family member that's working in a business, somebody that's working part-time, seasonal, et cetera, if you're going to hire somebody, they would need coverage from day one. So the moment you're going to put them on that individual on the payroll, you would need workers' compensation coverage. There's no cutoff in terms of they have to work a certain amount of hours a week, et cetera. And then disability benefits, if you're starting employees, you have a little bit more time. It's 4 weeks after the 30th day of employment for that individual or those persons that you hire. And how do we define an employee? It's anybody who's providing service to a for-profit business can be deemed to be an employee of that particular business. So anytime you're, you know, even if that person is a volunteer in your business, we like to say there's no volunteers in a for-profit business. So you want to make sure that, you know, if you're having a family member helping you out, maybe doing some bookkeeping for you, et cetera, making some deliveries in your business, even if you're not paying that individual, you would need to have workers' compensation coverage because they would be entitled to benefits should they become injured on the job. And then any compensated individuals that's providing services to a nonprofit can also be determined to be an employee of that nonprofit. There's some limited exceptions there for clergies and teachers that are in a 501c3 not-for-profit, but if you have a not-for-profit, it could be a little league, et cetera, you're paying coaches, you're paying instructors, you would need to have coverage for that entity. So who's not required to carry the coverage? All these instances we're going to go through, these individuals or persons, although they're not required to get the coverage, they can get it. So if you're a sole proprietor, you have no employees, just one man, one woman operation, you'd be exempt from getting workers' compensation coverage. If you're a partner in a partnership that has no employees, so PLLP, LLP, et cetera, you and somebody are partners. As long as everybody's a partner in the business and there's no additional employees outside of the partners, you'd be exempt from coverage. And then 1 or 2 person-owned corporations that have no employees are exempt as well. The caveat there is if it's a 2 person-owned corporation, each of the individuals has to hold one of the offices. Between the 2 of them, they would have to hold both offices, and they each have to own at least 1 share of stock and 100% ownership between the 2 of them. So if you're setting up a corporation, 2-person corporation, to be exempt, you would have to meet those type of criteria. And then also LLCs. If the only people compensated are members of that LLC, they would not need coverage. And just to reiterate, all these individuals can go out and get a policy, because if you're a sole proprietor and you don't have coverage, you get injured on the job to the extent where you cannot, you know, do that particular job anymore, there's going to be no benefits for it. So you would not be entitled to wage replacement or any type of medical you know, coverage for that injury. So even though you're exempt, you can still go out and get a policy for yourself. Disability and paid family leave, sole proprietors and other self-employers may voluntarily opt in for that coverage. If it's a new business and they opt in within the first 26 weeks of starting that business, there's no waiting period for the benefits. So about 6 months in, if you decide you want it, if you do it before that point, you wouldn't have to wait to take those benefits. If you opt in after 26 weeks of starting that business, there's a 2-year waiting period to take advantage of that PFL benefit. Okay. We get a lot of questions regarding independent contractors. Just because you're paying somebody on a 1099 or what have you, it doesn't necessarily mean that they're a quote-unquote independent contractor for workers' compensation purposes. We look at the direction and control. Are you telling that individual, you know, what time to show up, what their hours are going to be for the day or the week? Do you have direction and control of that individual? Does the individual have a separate FEIN number and they file their own IRS tax return or business tax return? Does that individual maintain a separate business establishment from the hiring business? Those are some of the factors that we look at, whether we determine that somebody being hired as an independent contractor or actually an employee for workers' compensation insurance purposes. And if you have any questions on it, you can visit our employer section of the website, wcb.ny.gov. There's some more detailed information on the factors to look at. Under the Construction Workers Industry Fair Play Act, workers are presumed to be an employee of the hiring business unless they can prove they have their own business. There's a 12-point test for that. That's right on the Department of Labor's website. So if you're a general contractor, you're hiring separate tradespeople, like a framer, mason, et cetera. Generally, they would be considered to be independent contractors. You would not need to have coverage for them. They should have their own coverage in place. But you can go to that test right on the Department of Labor's website under the Construction Industry Fair Play Act and take, for more detailed information, take a look at that, okay? General contractors, again, they're liable for any workers' comp claims of any uninsured subcontractors. So what we highly recommend is if you're that general contractor, even if you're exempt, you want to make sure that your subcontractors that you hire, that they add you as a certificate holder on their New York State workers' compensation policy for two reasons. One, if there's any material change to the policy, so if that subcontractor stops paying their premium or anything, you're going to get, as a certificate holder on the policy, you're going to get notification that they're no longer insured or that they were canceled for not paying their premium, et cetera. Also, on an annual basis, your insurance carrier is going to do a premium and payroll audit, and they're going to look at anything you paid to uninsured subcontractors. They're going to charge you premium to any monies you paid to uninsured subcontractors. So if you have an insurance certificate from those individuals and you can prove that the subcontractor or subcontractors were, in fact, have their own policy, you're not going to pay any type of additional premium for anything that you paid them. So it's important that as a general contractor, you make sure that the subs you have coverage in their own name and FEIN number, and you get a certificate naming you as a certificate holder of their policy. Some of the costs and premiums, okay, generally there's a 4-digit classification code for every job in New York State. It basically speaks to how hazardous is that particular job. So obviously your construction trades, factory, et cetera, is going to be a higher cost per $100 worth of payroll than, if you're running a call center or, some type of office administrative employees. The rates are per $100 worth of payroll, so it's dependent on how high your payroll is. And then also how safely you operate your business, much like your auto insurance. If you have a few fender benders on there or DWI, you're going to pay more than somebody that has, very few claims or no claims as far as workers' compensation goes. Carriers will then do an audit, like we spoke about, on an annual basis to make sure that, your payroll matches what you're reporting to them. I think there's about 240 carriers in New York State, the large companies like Travelers, State Farm, et cetera. Then you also have the New York State Insurance Fund. So there is competition within the marketplace. So our advice as a business owner is you want to check around and you want to shop rates. Workers' compensation insurance is statutory, so every policy essentially covers the same policy in terms of coverage. There's no, higher level policy you can get or low level policy you can get or higher deductible, low deductible, et cetera. So there's competition in the marketplace in terms of price, how well those carriers invest that premium, what their administrative expenses are. So you want, if you can, you want to shop around and talk to your insurance agent or broker and get a couple of quotes and see if you can save money by going with a different carrier. Okay. The assessment rate, which is essentially the percentage of premium that goes to funding the board's operations, the workers' comp board operations, that went down effective January 1 of 2025 to 7.1%. It was originally 9.2%, which represents a 2.1% decrease and presents a potential savings of $191 million to businesses in New York State. So hopefully those savings from the insurance carriers are realizing and passed on to their policyholders. Disability benefits, it's calculated per $100 worth of payroll as well. The employer may deduct a partial contribution from their employees, and that the maximum is 0.5% of their wages, which can be no more than 60 cents per week. The employer would pay the rest. Okay. Again, for paid family leave, they may deduct the whole. The employer may deduct the whole total, and they get paid for by the employee, and that rate is 0.38%, which is capped at $354 a year. So about $7 a week that the employee is paying out of their paycheck to take advantage of that benefit. Okay. Some of the penalties that we have in our office, at the advocate's office, we work hard to mitigate those penalties to the employers if they're found to be in violation of the workers' comp law. It can be up to $2,000 for every 10 days of noncompliance. So every 10 days you don't have workers' comp insurance, you should have had it. It can be up to a $2,000 penalty. It comes out to about $72,000 a year. Additionally, up to 5 employees is a misdemeanor with a maximum penalty of $5,000. More than 5 can be a felony, subject to a maximum $50,000 penalty. Okay, so you want to make sure that, you know, you have that coverage in place because the cost of not having it can be a lot more than the cost of actually getting the insurance. And if you're misclassifying employees, which is essentially, we talked about those classification codes, and if you're hiding payroll in a classification code that may be cheaper than what the worker is actually doing, that's the same as being uninsured. So if you have a bunch of, you know, if you run a roofing business, you have a bunch of people performing roofing duties, and you're saying that you have a lot more office expense, you know, than you actually have because you want to pay a cheaper premium or a cheaper rate, that's misclassification, and that's the same thing as being uninsured. So the penalties above would apply. As far as disability and paid family benefits, the penalties, the noncompliance penalties, it's 0.5% of the employer's payroll during the period of noncompliance. It can also be a misdemeanor subject to a $100 to $500 fine, and then imprisonment up to 1 year of both a fine and imprisonment, as well as additional violations. But the board is not in the business of putting anybody in prison. We want to work with the business to get them in compliance so their employees are protected, and then we'll take a look at, you know, what's a fair penalty. A lot of times what we'll do is we'll ask that employer, once they go out and get the coverage, to submit a copy of their policy. We'll look at the premium for what they would have paid during that time period that they did not have the coverage, and we'll base any type of fine or penalty off their actual premium and not that $2,000 for 10 days. Okay. Also, it's become a bigger issue lately. If you are found to not have workers' compensation insurance and you needed to have it, you go on the debarment list, okay, which prevents you from getting any type of bidding on or being awarded any type of public work contract or subcontract with New York State or any municipal corporation or body for a 1-year period. So that's, you know, at the county level, whether that's you're getting a contract, you want to get some type of permit, or you're doing business with New York State, you're selling them, you know, goods or services. That's a 1-year ban on any type of public works contract. So you want to be careful that you do not, you know, not fall in violation. And for every felony conviction, the ban is 5 years. How can you control your costs as an employer? With some safety and loss prevention methods. You know, look at the classification codes. Be sure that the correct classification code is being applied. Sometimes, you know, your business changes a little bit, and the duties that the individuals are doing that work for you change. So, you know, keep up to date on those class codes. If your business does change a little bit, or you add a new line of business, make sure that, you know, it's being represented correctly, because that's the way your premium is calculated. All right, and then you want to follow your claims. Make sure you stay informed. You know, keep in touch with that injured worker. All right, there's a lot of studies that show the longer somebody's out of work, the less likely they are to come back from a workers' comp injury. And then make sure you're operating your business safely. You know, look around if you're having a bunch of slips and falls or a bunch of back strains. Make sure those the employees are trained, you know, to lift properly, or, you know, the shop floor isn't, you know, does not have extension cords laying all over the place, etc. You can also form a labor management safety committee. It's a pretty simple process. Regardless of the size of your business, you can do this. You can work together to avoid these incidents. All you want to do is make sure you have an equal number of members from both the labor and the management side. Appoint a chairperson of that committee and rotate that individual regularly. And then have a regularly scheduled meeting, whether it's you know, monthly, quarterly, etc. Some of the tasks, you can visit the workplaces if you have several work sites, review the policies and procedures, and then establish safe procedures and train any new and existing employees to operate safely or work safely. The New York State Department of Labor offers a free and confidential on-site consultation program. It's not there to you know, to report you to OSHA or issue any fines. It doesn't do that. Everything is confidential. They come on site with trained individuals, and they'll visit your workplace and help you mitigate those safety risks, all right? It's a confidential thing. They're not gonna, report back to you. They're not gonna penalize you or anything like that. It's a free service that DOL offers. Some of the stuff they do air and noise sampling, site hazard assessments. If you want more information on that program or want to set something up, you can give them a call. The number is below, 518-457-2238. Okay. New York State Department of Labor also offers a workplace loss prevention safety incentive program for any businesses that voluntarily establish a safety, drug, alcohol prevention or return to work program. You can save up to 10% in that first year of operation, and then years 2 and 3, you can save an additional 6%. Okay, if you have all 3 of those in place. They must be evaluated by a certified safety specialist, all right? And many insurance carriers have their own specialists, so you could talk to your insurance carrier and ask them about Code Rule 60. That's the title of the program for the Safety, Alcohol, and Drug Prevention Program. If you wanted to go on the Department of Labor's website, they also have a list of certified specialists you can reach out to get more information. There's no cost, to ask them a question or call them up or send them an email and talk about it and see if the program makes sense for your business. Also on that website, they have model programs that they've implemented in the past, and there's other resources and links on how to get going on those types of programs. Okay. Return to work, you want to help the workers get better and get back to their job. A quick and safe return to a healthy lifestyle helps employees get better, okay? Research shows the longer an employee is out of work, the less likely they are to come back, okay? So just 50% of injured employees will return to work after a 6-month absence. So you want to make sure, even if you have some type of light duty that an individual can do, if they're released to do some type of light duty by their physician, whether it's a part-time basis, et cetera, if they can't perform their full duties, but there's something you have that they can do that meets that light duty requirement, get them back on, get them back in the office or the shop or what have you, even if it's on a part-time basis, so they feel attached to their coworkers and their job. They can continue working while recovering from that injury and illness. They would get a reduced earning benefit if they return to work at a lower pay rate because their current injury prevents them from working at that pre-injury level. And again, medical care for a work injury, it's a lifetime benefit. So even after they return to work, if they, had some flare-up or what have you, they would continue to receive medical benefits as long as it was causally related to that original injury, unless they sign some type of legal settlement that says otherwise. But for the most part, those benefits continue for the life of that claim, even after the person returns to their old job, at full duty. Okay. If there is an injury, you want to make sure that you get the injured worker gets necessary medical treatment right away. You're going to record the details about the incident, what, where, when, and how. Let your insurance carrier know about that injury. If the injury will cause lost time beyond that day off, or if it requires medical treatment beyond ordinary first aid. So if it's something when somebody just cuts themselves, they put a Band-Aid and they just, they're out for the rest of their shift or what have you, doesn't necessarily, have to be reported to your insurance carrier. But if it's something that's going to require medical treatment beyond first aid and lost time beyond the day of that particular injury, you'd want to notify your insurance carrier. The employee is going to file the claim form, which is a C3 with the board, and they must notify their employee in writing 30 days after that incident. So sometimes an employee might be injured but might not realize it's their back or something like that. It's not noticeable right away, but as soon as they realize that there's an injury, they have 30 days to notify their employer after that incident. Many employees continue to pay their wages following a work-related illness. That's perfectly fine, but the employer may seek reimbursement of those wage payments out of any awards of compensation for that individual. The employer has to make a claim for reimbursement prior to the award of compensation. So if you continue to pay that individual and you want to seek reimbursement, you're entitled to do such, but you have have to make that claim prior to the award of the compensation. When an injured worker returns to their job, you want to notify the insurance carrier, let them know that the individual is returned to work. If they're performing light duty with a reduced salary, they may still qualify for some wage replacement to get them up to that full benefit. If they return to their old job at their previous wage, they're no longer entitled to those wage replacement benefits. And if they return to work without disclosing it, they can face fraud charges. Right? So they have to let their employer, the injured worker would have to let their employer know that they're returning. And again, that medically necessary treatment for that work-related injury is a lifetime benefit, so they're still entitled to medical benefits after they return to work. Just to sorry about that. As an employer responsibility, you want to make sure you have the required insurance. Once you have it, you're going to get an insurance poster, the C-105 on the workers' comp side, from the insurance carrier. You post that, in the break room or someplace where your employees might congregate. You want to report any claims in a timely fashion. And Section 120 of our law states that an employee cannot be discriminated against for filing a claim. So they can only be terminated for a valid business reason, whether that's misconduct, insubordination, lack of work, lengthy absence from work, et cetera. You can't terminate someone's employment because they filed a workers' compensation claim. And they're eligible for those benefits, regardless of their citizenship and or immigration status. 9/11 assistance is a program that was set up after the terrorist attacks on 9/11. You may be eligible if you were exposed to no-cost health care and or financial compensation from the federal government. If you're a 9/11 responder, worker, resident, and or a student in that area, if you meet one of those criteria above, you just want to visit the website for more information, ny.gov/September 11, to see if you're eligible for financial compensation and no-cost health care. The board is building a new business information system. It's called Onboard. It gives you access to real-time claims, online self-service. You can find out more information. Onboard has their own website, housed on the board's website, wcb.ny.gov/onboard. There's the walkthrough of the registration process. There's some tutorials on there. Also, you can find recorded presentations. This presentation is on there, as well as our Advocate for Injured Workers presentation, and other video tutorials that our PIO staff has put out. Okay. The board also is on social media. We have our own Twitter, X account, Facebook page, Instagram, YouTube, also LinkedIn. And you can sign up for notifications via email from us. And you can select whatever notifications you'd like to receive, so we're not bombarding your inbox. Whether you're interested in employer notifications, insurance carriers, injured workers, claim stuff, we'll send you emails regarding those subject matters. Okay. Our office, again, the Office of the Advocate for Business, it's our helpline, which is staffed with a live person from 8:30 to 4:30, Monday to Friday, 518-486-3331. You can email us at advocatebusiness@wcb.ny.gov. If you have any questions or concerns, be happy. If you received a notice from the board and there's some type of penalty issue, or you're starting a business and you have some questions as to whether you need coverage, don't need coverage, et cetera, reach out to us either by phone or email. Be happy to help you. We also have our own section of the website, wcb.ny.gov/AFB. Okay. At this point, if you have any questions, we'll briefly pause it. You can put those in the chat, and Sarah and I will come back and we'll try to answer all of your questions.
Okay, well, thank you. And while Walt is catching his breath here, I just know that we have some questions that came into the chat regarding the PowerPoint, whether we're going to be sharing this presentation. What we do is we will actually put a recording of this on our YouTube channel and post it to our recorded webinar section of our website. So if you go to the home page and scroll all the way down to the bottom, you'll see recorded webinars. You can go in there and you'll see different sections. One of those is the Office of the Business Advocate, and you'll see that all your previously recorded webinars are there. I also wanted to point out, in addition, if you haven't been to our YouTube channel, there is these webinar recordings and a bunch of other ones there that are great resources for everyone. So like Walt said, we're just going to take a brief pause here. We're going to review the questions, and we'll be right back. Okay, I just wanted to point out another thing for people that actually want the PowerPoint presentation itself. We ask that you email the advocate office, the business office, and they will send a copy of the presentation to you. So I just backed up the slides here, so you actually have the email address as well, and that way you can email them and request. All right, our first question here for Walt is, do employees get 12 weeks of PFL for every instance of care for a family member, or is it just 12 weeks in the 52-week period regardless? They gave an example. If an employee needs to care for multiple family members or needs to care for a family member and needs to bond with a newborn. That makes sense there for you?
So it's 12 weeks of total leave. So whether you have one instance or three instances, you get 12 weeks within a 52-week period. So if you have twins or something, you don't get 24 weeks. The benefit is 12 weeks in a 52-week period.
Okay, thank you. And next question here. In the LLC exception, is there a limit on the number of members?
There's no limit. As long as everybody is a member of that LLC, whether it's 2 people or 22 people, there's no limit on the total number. But if you have employees who are not members of the LLC, you would be covered.
Okay. Our next question here, someone was looking to see if you could kindly revisit the workers' comp requirements for non-paid volunteers at a 501c3 nonprofit organization.
Yeah, so that exemption, if they're not paid and they're not doing manual labor, they would be exempt. But if that same 501c3, the example I use is it's a church and, you know, they pay an organist, but, you know, in addition they have a priest, et cetera. The priest would be exempt, but you would need to have coverage for the organist or the singers, you know, in the choir if you were compensating those individuals.
Great. Our next question here is, how can we ultimately guarantee the code for workers' comp policy is correct? For an engraving business, we have a various code listed in quotes from various providers. How can we ensure the code is correct if we are a new business?
You can look at the code. The listing of the codes is the Compensation Insurance Rating Board is the one that oversees those codes. If you just Google Compensation Insurance Rating Board, their website will come up, and you can look at those quotes. And you know, I would talk to my agent if you work with an agent or broker. Talk to them about the codes that are being used. If you work directly with an insurance carrier, you know, you can look at the various codes under that business, and you know, might be able to find the code that fits you the best. You know, ultimately the carrier assigns those codes, so it'll be up to you as the employer if you wanted to dispute, you know, that particular code that's being used. But there's like almost like subcodes under each one. So, you know, if it's a little bit different than what you think it is, you can talk to your carrier or your agent about, you know, getting a code that more accurately represents what the employees are doing.
Great, thank you. We had a request for someone to back up the slides again to the YouTube channel, so I'm just backing that up there. So the youtube.com/@NWSWCB is the YouTube channel there. So our next question here is, I work at a municipality that is having issues with employees filing claims without ever missing a day of work, yet collecting extensive multiple SLU awards. Can we avoid this problem somehow?
So SLU is a scheduled loss of use. If you know, there's a certain body part you injured and you lose a percentage of use of that shoulder, finger, what have you. That would be handled in the adjudication process. You know, that's ultimately up to a workers' comp law judge to issue that scheduled loss and use. So as a municipality, you know, generally there's a third-party administrator or TPA involved, as well as an insurance carrier or self-insurance. So they would fight, so to speak, on your behalf regarding that claim. Not something our office would handle, but you should talk to your TPA about that issue and see what they can do in terms of, you know, kind of speaking on your behalf.
Thanks, Walt. That is all the questions we have for right now. I'm going to give everybody a few minutes to put any additional questions they may have. I don't know if, Walt, if you wanted to kind of review the survey. Is there anything?
Yeah, there's a survey there. If you click on that QR code and complete that short survey, just scan it with your phone. We're always looking to improve our presentations and then offer additional resources for employers and businesses. So any feedback you have, we would appreciate it, whether it's positive or negative. Please let us know.
Great. Once again, I know we had to come into the chat again. This presentation, this webinar is recorded, and it will be available on our WCB website as well as our YouTube channel. So I'm just going to give everybody just one more minute here to see if we have any other questions that come in. All right, well, we haven't seen any other questions come in the chat, so thank you, Walt, and thank you to everyone for joining us today. Just a reminder, as part of the Advocate for Business series, this webinar will continue to be offered in the upcoming months, so if you need a refresher at any point or any of your colleagues couldn't join today's webinar, there'll be other opportunities. You can find a list of webinar dates for this series and a variety of other topics as well on the board's website at wcb.ny.gov/webinars. You can also sign up to receive workers' compensation news, which Walt had mentioned during his presentation, including information on future webinars straight to your inbox. To sign up, visit the Workers' Compensation Board website, scroll down to the bottom of the homepage, and select Get WCB Notifications. We also distribute information via our social media channels, so please follow the Workers' Compensation Board on Facebook, X, Instagram, and YouTube. Once again, thank you all for joining us today, and enjoy the rest of your afternoon.